for communicating with and serving customers in the life and health insurance industry. Well, welcome again to this fourth CAFII webinar of 2013, with our focus in this session being on the new Quebec Charter of the French language. My name is Keith Martin, and I am Co-Executive Director of the Canadian Association of Financial Institutions and Insurance, or CAFII. On behalf of myself and my Co-Executive Director colleague, Brendan Wicks, and the CAFII Board of Directors, thank you for joining us in our webinar today. CAFII is a not-for-profit association dedicated to the development of an open and flexible insurance marketplace. Our 15 members include the insurance arms of Canada's major banks and credit unions, along with their insurer partners, which underwrite credit protection insurance and travel insurance. This is another in our webinar series with key regulators, policymakers, and other experts and thought leaders in the insurance sector and on related societal issues. Now, as I mentioned earlier, the topic that we will be discussing today is Quebec's Bill 96. We're very fortunate in this regard to have two leading Quebec-based lawyers who practice in this area as our expert panelists today. Romy Prou is an associate in the Litigation and Dispute Resolution Group at Stikeman Elliott, based at the firm's Montreal office. Her practice encompasses all aspects of civil and commercial litigation, including matters relating to energy, construction, and corporate law. In addition to representing clients before the judicial and regulatory bodies of Quebec, Romy is regularly called upon to provide strategic advice on regulatory matters, including interpretation and enforcement of the Charter of the French language and Bill 96, an act respecting French, the official and common language of Quebec, which is, of course, today's subject. She also works on matters related to the enforcement of the Access to Information Act and the Privacy Act, among many other areas of expertise that she covers. Romy is a member of the Quebec Bar, the Young Bar Association of Montreal, and the CHU Sainte Justine Foundation's Winter Triathlon Organizing Committee. Our second legal expert panelist today is Paul Prosterman, a senior partner at Norton Rose Fulbright Canada LLP, and he's based at the firm's Montreal office as well. Paul practices mainly in the areas of insurance law, class actions, and pharmaceutical and consumer product liability. On the insurance front, he has considerable experience in representing insurers and other financial institutions, respecting insurance coverage, providing opinions and defending insurers' coverage positions, insurance defense, policy interpretation and drafting, Canadianizing policy wordings, professional liability insurance, and claims related to directors and officers' liability. He also works in technology errors and omissions and cyber liability, commercial general liability, and property insurance. He's licensed to practice law in Quebec, Ontario, and Saskatchewan. Paul's practice and experience span the breadth of Canada. He regularly works with clients based in this country, the United States, and Europe on matters requiring the collaboration and coordination of counsel in different jurisdictions. He has extensive experience in multi-jurisdictional litigation and coverage disputes involving insurance and product liability issues. So welcome to you both. We're very fortunate to have you. Members of the audience, I want to mention that if you have any questions that you would like to pose to our panelists at any time during the webinar, please send them to me as the host using the Q&A function of Zoom, which is located on an icon towards the bottom of Zoom, and I will pose those questions on your behalf. Unless you specifically request in your question to be identified as its source, I will pose all questions to the panelists on an anonymous basis. And just before we get the webinar underway, I want to extend a special welcome to a number of VIP attendees. In addition to many representatives from our 15 CAFII member companies and our 9 associates, which are key supplier companies to the bancassurance sector, we also have VIP attendees today from allied industry associations, such as the Canadian Life and Health Insurance Association, or the CLHIA, the Travel Health Insurance Association, or THIA, and the Canadian Bankers Association, or the CBA. As well, we have representatives from insurance and financial services, regulatory and policy-making authorities, including Quebec's Autorité des Marchés Financiers, or the AMF, the Government of Nova Scotia, the Alberta Treasury Board and Finance, and the Financial Regulatory Authority of Ontario, or FSRA. Welcome to you all. Now, to start, our panelists will share a short presentation, which is up on the screen, and I'll pass it over to Romy to get us started.
Good afternoon, everyone, and thanks, Keith, for the invitation and also for the good introduction. Since the adoption of Bill 96 in June of last year, Paul and I were called upon by our respective clients to provide advice on various French requirements issues, as well as to accompany clients with some of the OQLF, the Office Québécois de la Langue Française, investigations. We thought it would be interesting to highlight some of the new requirements which either came into force recently or are about to come into force and which are relevant and applicable to the life and health insurance sector. So before we dive into these new requirements, maybe a good idea to go back to basics for a second. So I know that Bill 96 has been all over the news for more than a year now. And to some people, it may sound like the requirements provided in this bill are entirely new. Well, in fact, while it is true that some new requirements were adopted under Bill 96, the truth is that Bill 96 mainly modified already existing requirements provided under the Charter of the French language. So as we see on the slide here, the Quebec Charter of the French language was adopted in 1977 to protect the status of the French in Quebec. The first provision of the charter states that French is the official language of the province of Quebec. And as you can also see on this slide, the charter provides for basic language rights in a variety of fields, but today's presentation will focus on the use of French in trades and businesses. Great. So Bill 96 amends the charter in many ways, and as you may have heard in the news, some of these changes related to the justice system, education, health services, etc. Put it another way, there weren't that many sectors that were not impacted by Bill 96. Because it is obviously impossible to cover everything in an hour or so, we will focus on the rules of the language of insurance policies and the rules governing the language of pleadings. These amendments to the charter are very recent, and some of them are not even into force yet. And as a result, we cannot rely on any case law or guidelines at the moment to interpret these amendments. Our best source of information right now are the parliamentary debates. And even after reading the transcript of these debates, there remains many gray areas. So Paul, maybe you can start with the rule governing the language of insurance policies.
Thanks, Romy, and thank you, Keith, for the invitation to be here. Hello, everybody. So turning to the amendments in Bill 96, which apply to the rules governing the language of insurance policies as such. More precisely, these amendments relate to the rules governing the language of all standard form contracts, also known as adhesion contracts. And as you might guess, insurance policies are usually considered to be adhesion contracts. And now under the current rules, adhesion contracts can be drawn up in English or in any language other than French for that matter, if it's the express wish of the parties. So you'll often find sort of that classic English language clause in Quebec contracts stating that this contract was drawn up in English at the express wish of the parties. Well, Bill 96 changes the rules in this regard, and that's probably one of the reasons why we're here today. And that's because starting on June 1st, 2023, parties to an adhesion contract drawn up in English can only be bound by that contract if they're first provided with the French version of the contract. And one might call this the French first rule. And in practice, this means that insurance policies must be drawn up in French or in French and English if an English version is elected. And at the very least, the French version of the policy must be available to the insured before entering the English policy. Now, there is an important exception to this rule provided for through Bill 96, and it specifically provides that insurance policies as such may be drawn up only in English if there's no French equivalent in Quebec, and the policy either comes from outside Quebec or its use is not widespread in Quebec. And the purpose of the exception seems relatively clear: to ensure that sophisticated insurance products are available to Quebec businesses, even if these contractual documents are only in English. But as we're going to discuss a little bit later on, the scope of the exception is not entirely clear, and we'll identify some of the issues that arise with it as we continue.
So turning now to the rules governing the language of pleadings. So as of now, the current situation is that legal persons may file pleadings in either French or English. And it is very common, especially with the globalization and internationalization of commercial activities, for pleadings to be drawn up in English. So for instance, even if a legal representative of a company located in Quebec speaks French, the CEO or the chief legal counsel may be working from the head office located in Ontario or in the US. And for this reason, they will want to review the proceeding before it's filed. So they will want this proceeding to be drafted in English.
Romy, if I could just ask you and Paul, could you just clarify what a pleading is?
Well, spoiler here, Keith, because we're about to
You're about to do that. Okay, perfect.
Well, I can do it right away. Pleadings would be something that is filed as, let's say, a originating application or a defense or a counterclaim, whereas affidavits and exhibits can be filed in English. So we'll make this distinction pretty quickly, but you're right, that is a pretty important distinction to make. So Bill 96 provides that legal persons, which include insurers and their commercial client, must now file their pleadings in French. It also adds that pleadings may be filed in English, but in this case, a French version prepared by a certified translator must be attached, and the legal person shall bear the translation cost. And this raises a number of issues, starting with the fact that depending on the length of the proceedings, it can be very expensive to obtain a certified translation. And this raises the question to access to justice, because some companies may not be able to afford the services of a certified translator. Also, the turnaround time to obtain a certified translation of a pleading can be rather long, and this poses problems in cases where there are strict deadlines, such as the upcoming expiration of a limitation period or deadlines related to appeal proceedings. There are few exceptions or things that are excluded from this rules. This does not apply to pleadings filed by individuals. It also does not apply to exhibits and affidavits, which can be drawn up in English, as the rule strictly applies to pleadings themselves. So like I said earlier, originating application, statement of defense, counterclaims. And finally, witnesses may testify in English. So these new rules were supposed to enter into force on September 1st, 2022. However, the constitutional validity is being challenged before the Superior Court. And in a decision rendered by Justice Chantal Corriveau in August 2022, the Superior Court suspended the application of these new requirements until the court determines whether such requirements are in fact valid or not. And the court has not rendered a decision on the merits yet. So the end result is that companies can still file pleadings in English for now, at least. Now, a few takeaways on our presentation so far. So insurance policies should be drafted in both French and English as of June 1st, 2023. There is an exception when it comes to insurance policy, which has no French equivalent in Quebec, and which either comes from outside Quebec or where its use is not widespread in Quebec. The scope of this exception is, however, not entirely clear, like Paul mentioned, and we're about to discuss that further. As regards to the rule governing the language of pleadings, there were amendments adopted under Bill 96, which require a legal person to file their pleadings in French, or if they choose to have them filed in English, then they need a certified version of this pleading. This has some important repercussions in terms of timing and cost, and the constitutional validity of this amendment is currently being challenged, such that these new rules are currently not applicable. So this is for the presentation part, or the PowerPoint presentation part. Oh, Keith, you're mute.
Keith, you're on mute.
Yes, we all got it.
At least
that was
one
very
second.
informative. Much appreciated. Thank you. Let's get into the next section where we can delve in more deeply on some of these issues. And I'll start with you, Paul. You touched on a contract of adhesion. Can you tell us what constitutes such a contract, especially with respect to credit protection insurance, creditors group insurance, as well as the various forms of travel insurance?
Sure. Well, we have a definition of what a contract of adhesion is. Article 1379 of the Civil Code of Quebec defines a contract of adhesion. It's a contract in which the essential stipulations were imposed upon or drawn up by one party, and they were not negotiable. So by contrast, a contract that's not a contract of adhesion, it's called a mutual agreement contract. And so we see what this definition has two criteria, basically. First, one party must have imposed or drawn up the essential terms of the contract. Second, those essential terms must also have been non-negotiable. And these terms will be considered to be imposed as such based on a factual analysis. It depends on the circumstances, whether there was no real possibility to freely negotiate these terms, yes or no. And in the context of insurance, both case law and doctrine indicate that insurance policies are generally contracts of adhesion. As we can imagine, insurers, particularly in this area, typically offer coverage under pre-printed forms that don't tend to allow much, if any, negotiation between the parties. The Quebec Superior Court has even gone so far as to state that the insurance policy has become the classic example of a contract of adhesion. Now, of course, if the facts should be such that an insurer can prove there was a negotiation between the parties on the essential terms, then an insurance policy will not be considered to be a contract of adhesion. In particular regard to credit protection insurance or creditors group insurance, travel insurance. So my thinking is that in relation to the policyholder, one can envisage negotiations on the essential terms of, let's say, if there's a master policy. So there will be an argument that the master policy is not a contract of adhesion. But in relation to insureds issued certificates of insurance under a master policy or insureds who are issued policies with preset terms, it seems quite clear we're in the realm of adhesion contracts. And I'll just add another point is that now let's turn to Bill 96. Now, what does that do to adhesion contracts? Well, the significant change has been, and we referred to this earlier, it happens to be Section 55 of the Charter, which pertains to contracts of adhesion. And this is what comes into force on June 1st. And that says it's that French first rule. Parties may only be bound by a version of an adhesion contract in a language other than French if, after the French version has been delivered to the adherent, the parties expressly wish to do so. So no longer sufficient to include that English language clause in contracts. And I would also say this applies to documents related to the contract. So in the context of insurance, this will include the obligation to deliver in French quotes, confirmations of cover, binders, policies, of course, and endorsements. So in practical terms, the party imposing the contractual terms here being the insurer, if they're the essential terms, must present a French version of the policy first, and the recipient can elect to be bound by a version drawn up in a language other than French. And it stands to reason if you've elected the policy in English, the documents that are related to it go hand in hand with that as well. We talked earlier about the exceptions to this rule. There are basically two. The first exception is, as we've described, where the recipient expressly has requested the documentation to be in a language other than French after having first been presented with the French version, then it can be in English. The second are those exceptions particular to insurance policies, which meet those criteria that were on the PowerPoint. One, the policy has no French equivalent in Quebec, and the policy either comes from outside Quebec or its use is not widespread in Quebec. And there's difficulty with these terms, and everybody out there has looked at them. They're in this realm of undetermined. So, for example, what is a French equivalent? How is equivalency to be measured? We have the term comes from outside Quebec. So this likely refers to non-domestic insurers like the Lloyd's, the London market. But in today's world, even foreign insurers have Canadian branches or they issue policies through local cover holders. So what does it mean for a policy to come from outside of Quebec? The same thing domestic insurers might ask themselves, does the policy have to be underwritten outside of Quebec, or does it have to be issued outside of Quebec? And then what qualifies for use of a policy wording which is not widespread? How limited does that have to be? Something less than not exclusive, right? Because it just says not widespread. And of course, interpreting this exception as applies to domestic insurers fairly remains to be determined as well.
Quick follow-up question for you, Paul. What if somebody has an existing certificate in English that was issued to them prior to the enforcement of Bill 96? Is this retroactive, or is that all right until such time as a renewal is issued?
It's fine until the renewal is issued. So this will be prospective.
And then I have a question from the audience, and please jump in as well, Romy, if you'd like. What does it mean to say an insurance policy comes from outside Quebec for a group policy that's bound in Ontario, between Ontario companies, for example, but for which there are members of the group who reside in Quebec?
Well, I'll take a first stab at that. That probably, first of all, there is no guidelines that have been published as yet, no regulations enacted either to provide further clarification. So these are going to be judgment calls you make on your own or with outside counsel or however you want to do it. In that type of situation, it strikes me that there may be a good argument that it comes from outside Quebec. But does it fulfill the other? If you're looking to see whether you fit into the exception, you have to remember that there are other dimensions to it, right? Policy has to have no French equivalent in Quebec. Query if that's the case. So you may have hit one of them, but perhaps not all of them.
Great. Well, Romy, maybe you can address that as well as another issue that I'm going to raise with you. I was at a session with about 35 Quebec business people in the insurance industry about a week ago, and really the whole discussion was around Bill 96. And as we went around the room, it was remarkable how many different interpretations there were of certain elements, how much, frankly, confusion there was about how to implement certain components. And it was very challenging because, you know, in the large companies that CAFII represents, you know, compliance and legal departments very much want to comply with existing laws and regulations, but many of these individuals weren't sure how to. So I know we talked about how this is untested new law, a lot of gray areas that you've already referenced. So I'd just like to get your advice. How do businesses operating in Quebec in the life and health insurance space proceed when there's so much uncertainty and so much gray areas?
Yeah, thank you, Keith. So for a second, I'm just going to exclude the businesses which are which operates in the life and health insurance space, just to tell you like a general approach that has been adopted by companies in Quebec. So it's a wait and see approach. And in a sense that companies prefer to take advantage in some sense of the numerous gray areas for now. So coming back to health insurance, I think for businesses operating in this space, I think the best approach would be to reach out to the OQLF, the Office Québécois de la langue française, once again. And I'm going to come back in about a second about how you should reach out to the OQLF. But why I say it's important, it would be important to reach out to the OQLF is to ensure that your practices are in compliance with the Charter's requirement. Because, and this is one point that I wanted to make with regard to a contract of adhesion, is that non-compliance with the rules governing adhesion contracts is presumed by the Charter to cause prejudice to the adherent party without the need of further evidence. So the contract may be declared null and void at the request of the party, or a party may claim damages. So because of the importance of the consequences if the provisions of the Charter are not respected, this is why I would advise companies to not hesitate to reach out to the OQLF instead of having the wait and see approach I was referring to. And coming back to my earlier point about how to communicate with the office, I would suggest to ask your external counsel to communicate with the OQLF on an anonymous basis. And I'm not saying that we should get more mandates. That's not what I'm saying. It's just because if you ask the question directly to the office, you have to deal with the answer you get from them. So it's a bit of a mix of the classic legal quote, never ask a question to which you do not already know the answer, and also be careful what you wish for, because if you do not get the answer you were looking for, you still have to apply the answer that was provided to you by the OQLF. And also, by asking the question directly to the office, you may bring unwanted attention to your company and open the door to further investigation by the office. So this is really something that you should think about before reaching out directly to the OQLF. But at the same time, it also helps you making sure that your practices are in compliance with the requirements or the new requirements.
And of course, associations is another way to try to get a broader than company-specific response. And what I've heard is that the OQLF has not been very responsive to inquiries. I don't know if that's changing, but that's sort of been our experience so far.
In my,
Go ahead.
I was just gonna say, in my experience, they really adopt the collaborative approach, and we can talk about that maybe later. But it's true that they do not like to issue legal opinion about that, but their website is very helpful, and also the guidelines are regularly issued on their websites, and the more and more these new provisions will come into force, the more and more guidelines we will have, and it should be a bit more clear how to interpret and apply these new provisions.
Okay, well, I'm going to ask a very, sorry, go ahead, Paul.
So I was just going to, I was just going to add that I think that's everything that Romy said is great practical advice on how to move forward. In coming up with what are one's procedures in-house, like what are the processes or the thought process, what guidelines one has in the industry in-house, I could tell you what some of the considerations are that we've seen and what we've been working on. So a lot of insurers are thinking about, first of all, whether they can avoid altogether being categorized as an adhesion contract, so that they could provide an English version without a French one. And then if there is an adhesion contract, if they fit into the exception, obviously. But to where there's a thinking that they may fit into an exception, some insurers are, in order to strengthen the position that a policy is bespoke, for example, and that it's been subject to negotiation, they'll add language prominently displayed on the certificate of insurance or on the declarations page, something that dovetails with the language in the legislation. So something like that, this document and any other document related with it, and a service and the policy will be in English, and that you acknowledge that you've asked for that, that the essential terms of the insurance have been subject to negotiation and were not imposed. It's also important to have a system in place to document the fact that an insured has requested either a document or a service in a language other than English. So if there's an email system, that they click something and they have a return email, you need to document that. The other thing I'd like to go back to, something that Romy raised in the beginning of this discussion, which is that let's not forget that the Charter of the French language has always stated that consumers have a right to be informed and served in French. There's nothing new about Bill 96 in that regard. So of course we're concerned with it today. Why? Because Bill 96 has added a new section. It happens to be section 50.2, which specifies that a business that offers services to consumers, the business must respect their right to be informed and served in French. And then the business that offers goods or services to a public other than consumers, so to other businesses or to governments, they also have to respect that right to inform and serve them in French. So one might ask, against that backdrop, how do you operate? Well, in our view, insurers should not view this section as prohibiting businesses from communicating with their clients in English. Okay, this is because this section, this prohibition, has to be read with other provisions in the Charter. And there are two sections, it's 89 and 91, and they provide that where the Charter does not require the use of French exclusively, then French and another language can be used together. And they also provide that where the Charter authorizes the drafting of a document, both in French and in other languages. It's okay. You can have both languages, but the French has to be displayed at least as prominently, and it must be understandable without having to refer to the version in the other language. There's also a checklist that the office has published that says that you have to serve clients in French. That's mandatory, but it acknowledges that if the services are offered in another language, the French has to be just as accessible. So clearly serving clients in a language other than French is envisaged by the charter. So there's a lot of course, uproar and concern about eliminating English altogether or any language other than French. And that's really not the case. It's more subtle than that. So kind of as general rules, we'd recommend insurers in the life and health insurance space communicate, inform insureds and other businesses in French first. They should ensure that French form is presented first, and then if they document if the other party has asked for the documentation to be in English or the service to be in English, etc. And then they can go ahead and do so. And if you're dealing with written documents, adhere to the requirements. French has to be at least as prominent, and it must be understandable without reference to the English version. But otherwise, you're able to deal with both.
All right, well, let me jump in on that with a very specific question, a very detailed question from one of our attendees. And it asks this: is it adequate to provide a customer with two insurance policies, the first attachment being French and the second attachment being in English, in one email? Or do you have to send two separate emails?
One email is okay.
Yeah.
Sorry, go ahead, Romy.
I think we were about to say the same thing. The only thing I would suggest or I would add is maybe in the way you draft your email is to say that attaches the insurance contract in English. We also attach an English version so that the way it is presented is French first and English second, but definitely you can send the you can have the two attachments in the same email.
Yeah, and I'd also add to that, that's exactly right. In the way it's presented, don't forget that the French has to be at least as prominent as the English, if not more prominent, but at least as prominent, and it has to be understandable without reference to the other version, right? It has to be complete in and of itself. But otherwise, you can.
I'll start with you, Romy. I want to ask you both to comment on a scenario that I've heard from some of our members, which is just to avoid uncertainty and sending documents in the wrong language. Some of our members are considering just basically sending everything in French first and English second. And this could have the ironic outcome that French speakers who previously just got French documents are now suddenly getting all these English documents that they don't want and that they didn't ask for, just simply because the company is trying to avoid the complexity in some cases of figuring out which language is sent in it, and also the risk of you sending it in English and maybe you got it wrong in terms of that person asking for that. So any comments on that?
Yeah, so to me, as long as the French version appears first or on the left-hand side of the page, like Paul mentioned earlier, I do not see any issue in proceeding this way. This technically complies with the law as it is currently drafted. So nothing prevents companies from sending written communication in both French and English. However, I would say that some companies, a bit like Paul mentioned earlier, have also begun implementing tools which allow consumers and clients to set their language preference for oral and written communication. So when I think I would encourage companies to do that just in order to avoid the situation you were mentioning earlier of having a client that was or that have always been communicated to in French receiving twice the document French and English now. But when a company decides to have such tool to allow consumers to elect their language preference, they should really ensure that they actually respect the language preference that is selected by the consumers or the client, because if not, it may open the door to complain to the UKLF, because this consumer would say, well, I specifically tick the box for French communication, and then I'm receiving either both. I don't think that both would truly be an issue and would be against the law, but if you begin sending erroneously communications in English to a consumer that has selected French, this could be an issue.
Yeah, and I would just, and I agree with what Romy has said. I think that, you know, it obviously creates duplication and it may create confusion as to whether the French was actually sent first, how it was presented. I think probably a safer bet is to present both together, with the French more prominent, or the French with an election, a manner for electing if they want to receive the document or the service in English thereafter.
I want to ask you some questions now about call centers, because there's some issue with our members about how to manage that channel. So, you know, one of the questions in general that we were hoping to get you to respond to was what a business that serves Quebec consumers and clients via a call center or contact center should take into consideration in terms of deciding its approach to be in compliance with the charter, both in terms of inbound and outbound communication. So I will ask you that question, but I'm going to add to it with a couple of more detailed questions from our audience, and I'll put them all together so you can have a comprehensive answer. So first question from the audience is, how can a company comply with Section 55 of Bill 96 in situations where the contract is binding over the phone and a copy of the insurance policy cannot be remitted to the customer prior to binding? Can the express wish for documents to be drawn in English happen over the phone, and then the French version of the policy be sent in the policy package? And the second question is, how can companies comply in respect of phone sales where French certificates of insurance cannot be delivered over the phone? So comments, Romy, do you want to start?
Sure. So with regard to the, I'll call it the phone issue. So the law mentioned that the parties cannot execute the English version of an adhesion contract before having seen a French version of the contract. So in and of itself, I think that if we read between the lines of the provision, there is nothing that would prevent. What I'm trying to say is that you need to see the French version before you execute the English version. So you need to find a way, in my view, you would need to find a way to make sure that before the parties enter into this contract, that the French version has been communicated to this consumer. And again, this is to ensure that you truly comply with the law, and that maybe the provision that you have in your English contract saying that a French version of the contract was provided first is true. I'm not sure if, Paul, you want to add to that or have different views.
No, I have the same view. And in terms of it being a call center, you know, and sort of in terms of there being a contract agreed verbally, that has to be in French first as well, right? So you have to be communicating that in French before an election is made to either conduct the rest of the conversation in English, and then what flows from there. And the scenario raises the question of, you know, the formation of a contract. There has to be a meeting of the minds, and that existed before Bill 96, and you know, and still exists today. So if there's a meeting of the minds on the contract and French is the language that was employed first, then I think then you're okay.
Quick question for you, Paul. Are some companies deciding to communicate only in French with Quebec consumers and clients going forward?
I know of a few. One in particular, it's a professional order, Quebec-based professional order, which is communicating strictly in French. And even though they have both Francophone and Anglophone members, so not their policy documentation is available in English, but it's not what they'll offer. It's not what they'll send out. There really has to be an election. But what's kind of interesting and is that, for example, we're involved in, say, doing coverage reviews or what have you. Even if it's an Anglophone member of the order, there's the coverage review, the correspondence to them will only be in French. So they've just adopted a French only rule, and they're sort of keeping it simple to a certain extent, notwithstanding complaints that they receive from their members. So some are, yes.
Yeah, I think it's more rare because like in your case, Paul, it's a professional order, but for companies, this could have the effect of limiting the activities of the companies, possible expansion of the companies or customer base. So I think it's really something that companies should be thinking about if they decide to adopt a French only policy. Yeah, so that was pretty much what I wanted to say.
Okay, thank you. I want to ask you both. We've already heard that there is a component of the bill that is suspended because of a Supreme Court challenge. Do you anticipate that there potentially could be other legal challenges and that there could be a sort of additional uncertainty because of those challenges? Paul, why don't I start with you?
It's always possible. You know, this is a landmine full of provisions which touch upon, to the most part, matters that are within the provincial sphere of competence, but not necessarily completely. So there might be other challenges of a constitutional nature related to competition. We don't have a crystal ball, but I don't think the story is told yet. And we also, in terms of the written pleadings that Romy described in the beginning, that's also kind of a long journey because we can expect that the Supreme Court is going to have something to say about that. So that will take a while to move through that process. Depends what they hold, what impact that will have on this legislation or certain parts of this legislation.
Romy, what are your thoughts on this?
Yeah, I think that the language of the pleadings was really, let's say, the tip of the iceberg, because you have the easy argument, not easy argument, but the obvious argument of constitutional right and the right of being able to present your case in French or in English. I think what I envision as being the next challenge is the fact that in June 2025, there are requirements that will come into force with regard to product labeling as well as public signs. And there will be, I think there will be challenge because it affects trademarks for companies. And a bit like Paul was saying, like there is the constitutional argument, but there is also a competency argument with regard to federal and provincial legislation. So in this case, the charter affects the trademarks and the Trademarks Act with adding some requirements with regard to the trademarks that you may have on public signs outside of your building, as well as the labeling and the packaging of your products. So this is something that I see going to court within the next year or so, because it's coming into force, like I said, in June 2025, and there are no regulations yet, but it's so unclear that I think that people will want to be proactive and maybe go to court to see how they're supposed to act or to apply the new requirements.
Okay, thank you. Romy, let me start with you, and then I'll ask Paul to speak on this. A question from the audience. And it's about online sales of insurance products. So you're online, digital purchase. What constitutes, in that case, a French version first? Is it a link to the French version? Is that sufficient, or is something else required? What are your thoughts, Romy?
Yeah, I think the link to the contract should be enough in my mind. Also, like I think the first thing is that the person should be able to decide the language of the website, and it's also another requirements that we did not touch upon because it's something that has not been changed with Bill 96. So the website has to be in French, or in French and in English. And then I think at that point, if the person would choose English, you would need to at least make sure that the French contract is available at some point and reviewed before they can actually execute or go with the English version.
So I agree with that. I think that if you're talking about a link, it raises the interesting sort of question as to complying with the requirement that French has to be as predominant as the English. So, you know, you just want to make sure that how the link is presented, and then, you know, when you take it to the text, how the text appears. It may sound pedantic, but you have to pay attention to that type of stuff.
But Paul, there's a practical issue that this raises that I know some of our members have mentioned, and it's the following. So you need to present the French first, and you need to request of the person their consent, express consent to get the documentation in English, or the contract in English. But you need to present that first in French. So they have to potentially read the French and then understand in French that they have to have express consent to receive further documentation in English. Is this something that you've heard as an issue?
It's an issue, but it's the issue the way you framed it, because I think you can present both French and English together, as long as the French is predominant and it's understandable without reference to the version in the other language. So
side by side, for example, Paul.
Side by side, one after the French first, English to follow, etc. And then you can include a link or a way to elect for future communications or the decisions with respect to the language of the services or the documentation, etc. So you can present together. You just need to respect the predominancy rule and the understandable in and of itself rule.
Okay, so that's manageable if it's done properly.
I think so, yeah.
Here's a question from the audience. I'm sorry, Romy, did you want to jump in on that?
No, I was fully.
Excellent. So let me start with you, Romy, then on this next question. How does the legislation apply to digital sales processes where the customer selects either English or French for the process at the start? If the Quebec customer selects the English process, does the financial institution still need to include French versions of the contract in the English digital flow? And I think I can answer that one. I think it's yes.
Good.
Is that correct? Yeah.
100% for you. Yeah. I think the fact that someone elects French and English or elects English does not subtract the obligation to provide the contract in French first.
I think it's safer. It's a safer practice.
To be entirely clear, this is the obligation is to provide the contract in French first. The truth is that if the consumer selected English, the risks of him complaining to the OQLF and try to have this contract nullified or try to move forward with the fact that the requirement was not fully, or the requirement was violated, is very low. But at the same time, you want to avoid having the risk of someone being able to complain with a technicality, quote unquote.
But I think at some point in the process, an election has to count, and it has to be kind of final. It's difficult without understanding, the entire process and what the documents are, to sort of say at what point that becomes the case. But at some point, you're allowed to elect to have a language other than French, and that has to have meaning as well.
Okay, good. This has been great. We've really gotten tremendous amounts of insights and information. We just have 10 minutes left. I just have a few extra questions. And one of them, again, is from the audience. So let me read it. Section 55 provides the requirement to provide a French version first, and this applies when parties wish to be bound only by the version in a language other than French. If parties agree to be bound by both versions of a contract, does the requirement to provide the French version first still apply?
I would think so, but because if the parties agree to be bound by both, why wouldn't you provide the French version first or first?
So basically, that's like the fundamental rule, right? Yeah.
And I would also say that if they're agreed to be bound by both, it means they're agreeing to be bound by the English, which means they have to put the French first. Like the French has to be there and the English, following. So
exactly, the fact that English is there at some point, you need to respect the rules of providing French first. Then
right.
Now back to the contracts of adhesion quickly. With national insurance providers, would geographical presence or scope of business nullify the condition around contracts of adhesion not being widespread, therefore making their translation a requirement? And The answer is yes, isn't it?
Well, to me, I feel like if it's something that can be used or that the use is widespread across Canada, I think it's not, it would be harder to justify the fact that you would fall within the exception of the use not being widespread in Quebec.
I agree. I think the exception is really for those types of coverages that are uncommon, or that are, or what's uncommon today may not be what's uncommon, a few years from now either. So it's kind of a moving target, but a product that's available across the country, or it's hard to see how that's going to qualify.
I want to sort of end in terms of the questions before I turn to each of you for your final thoughts with some insights from you around enforcement. I know, Romy, earlier on you said that you felt the Office Québécois de la langue française, OQLF, was collaborative, was wanting to try to work with stakeholders to sort all this out. But they do have enforcement capabilities, and enforcement could be a variety of things. It can even include name and shame, potentially, where it's reputational risk that you're worried about. I know some of our members have felt that this will take a little time to sort out. Others have felt that the OQLF will have a lot of pressure on it to demonstrate that it's that large companies in particular are conforming, and they'll want to do that from day one. And of course, if you get a newspaper article suggesting that there isn't conformity, sometimes it's difficult to control, because then the government doesn't want to look like it's not enforcing its own laws, and it can result in its own dynamic. So could you talk to us about your thoughts on enforcement and timelines for when it's going to become more sort of rigid, and how companies can sort of mitigate that risk? Romy, let me start with you, and then I'll ask Paul for his thoughts.
Yes. So since the adoption of Bill 96, one of the consequences was that the OQLF has now more means to ensure the enforcement of the charter's requirements. So just broadly speaking, the office can impose fines. It can order companies that are in violation to comply with the obligation of the charter or to cease contravening it. And it can specify a deadline for doing so. And it can also apply to a judge of the Superior Court for an injunction concerning the application of the charter. So this is what can be done by the office or the OQLF. But I think what's more important is what the office actually does in the case of a violation. So it will, just to reassure everyone not on the screen, but that is in line, that a notice will first be sent to the company and to inform the company that a situation violates one or many of the provisions of the charter. And at the end of the notice, and that's where I said that the approach that has been adopted by the OQLF is one of collaboration, is that they will invite the company to reach out to the OQLF for the OQLF to provide further information and guidance. And the OQLF is really not about money. It's really more about compliance, ensuring that companies comply with the requirements of the charter. And the two most important things for me is that the reason why the office may want to be more aggressive is with a company that does not, or if a notice remains unanswered. So that will be one. And also if a company violates the same provision over and over again without taking the requirements of the charter seriously. So coming back to what you were saying, Keith, in terms of reputation, I think that's where the risk lies, because if the OQLF feels that a company is not taking its intervention seriously, that's where fines or sanctions will be imposed, and that you have the risk of being in the front page of media, newspapers and media. So
flagrant violations are what you're talking about.
Yeah, flagrant violation, or just if repeated. Like the worst approach would be to think that it's only a notice, I'm not gonna answer, it's gonna go away. to the contrary, they're gonna come back more and just keep digging into the operations of the company to see if there are other violations.
Thank you, Romy. Paul, you want to add to that?
Yeah, well, I agree with everything Romy has said. A couple of things to highlight as well, and I think this will only be applied in sort of egregious situations of repeat offenders, whatever, but directors of a company can also be held liable for offenses to the charter. So that's something that, kind of gets, boards kind of get skittish about stuff like that. The other thing is that injunctions can apply, can be requested in respect not only of the owner of the non-compliant sort of advertising material, if you look at that, but also against whoever placed it, in a public way. So the reach is pretty broad, but I think that the approach of the office is exactly what Romy described it.
Well, you've just been a terrific panel. Both of you have been so insightful. I can't thank you enough on behalf of CAFII and our members. I just want to end the webinar by asking you each for your final thoughts. Paul, start us off.
I guess final thoughts are taking a step back and putting it into context. And I say I'm going back to sort of first principles that, French has always, since 1977, it's been the official language of the province. Consumers are allowed to be informed and served in French. This is an extension of that. And it's an effort to ensure that businesses are more compliant with that principle that has always been there. And I think it's a manner of trying to put it into practice. Sometimes it's not a smooth process, but I think that's the objective. And if you have that objective in mind, you're able to, I think, put processes in place which comply with that.
And to add to that, I would say that, and I don't want to reduce the importance of what we said earlier, but I think to a certain extent, it's really a question of optics and throughout the application of the charter. So if a company is able to demonstrate that it is putting in the efforts to try to comply with the law, even though it's not perfect yet, or it's not as perfect as the OQLF would like it to be, I think it's always a good start. And this applies to because we didn't touch upon the employee side of Bill 96, but there are a lot of requirements in this regard. So I feel like as long as the company is able to show that it's putting in the effort, the risk of having the OQLF in your face are very limited. So it's really about this approach and taking it seriously in order to show respect to French-speaking people.
Well, that's a reassuring way to end the webinar. I appreciate all of your comments. Paul, Romy, thank you so much. And to all of our attendees today, have a great rest of your day. Thank you both again. And we look forward to keeping in touch with you. Have a great day.
Thank you, everyone.